Thank you. My name is Aine Flynn and I'm Director of the Decision Support Service. That's the new service established under the Assisted Decision Making Capacity Act of 2015. And thank you to St John of God Research Foundation for having me to present to you. What I would propose is to provide a brief overview of the main provisions of the Assisted Decision Making Capacity Act. I will say a little bit about how that interacts with the Mental Health Act and with mental health services more generally, and then give you some idea of where we are on the pathway to implementation. And I propose dealing with the Act itself quite briefly. I know that some of you will have a level of familiarity already. So it is in its long title then described as an act to provide for the reform of the law relating to persons who require or may assistance in exercising their decision-making immediately or in the future. It is fully enacted legislation signed into law by the President right at the end of 2015, but not yet fully commenced. So a lot of what I'm talking about does relate to the post-commencement stage. The Department of Justice indicated by their estimates that more than 200,000 people could be affected by this act, and included within that number they had 100,000 people or thereabouts who are adults with long-standing mental health conditions which may affect their decision-making capacity. It's important to say that it's not necessarily true that any one of that number necessarily will require the supports offered by the Act. That will depend entirely on individual circumstances. And to give a little bit of international context, the commencement of the Act has been identified as essential to Ireland being compliant with the United Nations Convention on the Rights of Persons with Disability, which Ireland signed right at the beginning of 2018. And that's an international convention which obliges Ireland to ensure and guarantee the rights of persons with disability and their equal recognition before the law. And the social model of disability which the Convention adopts includes those with enduring mental illness. The key reforms under the Act include the abolition of our current wards of court system. Some of you will be familiar, or people in your services who are wards of court, and you will be aware that in order to make healthcare decisions around wards, you have to refer to the court. So post-commencement, there will be no new applications for wardship, and all people who are currently wards, and there are over 2,100 or so of those, all current wards will exit wardship and transition, if necessary, to the new supports within 3 years of commencement. And I'll now just touch on the other key reforms. And first of these then is the statutory functional assessment of capacity. So there's no diagnostic criteria or medical type threshold for a finding of incapacity. And in this respect, the Assisted Decision Making Capacity Act contrasts with comparable legislation in England and Wales, which describes incapacity as deriving from a disturbance or an impairment in functioning of the mind or brain. With limited exceptions, the Act is not prescriptive or exhaustive about who may assess capacity, and a person lacks capacity then on this analysis if that person is unable to understand, retain, weigh up the information which is relevant to making a decision, and then communicate with appropriate assistance if necessary what their decision is. And important to say, this is merely putting on a statutory basis what already is the applicable standard at common law and policy. So you already see that functional assessment in medical council guidelines and, for example, in the HSE national consent policy. So it's how capacity is supposed to be assessed already. The guiding principles, and these are just some of them in the 2015 Act, include a statutory presumption of capacity, again, already the applicable standard at common law. There's an obligation to support persons to make their own decisions as far as possible. And in that regard, I've sometimes said that, in a way, the brackets in the title of the Act, the Assisted Decision Making brackets Capacity Act, are significant because the priority of this legislation is about supporting people to exercise their decision-making autonomy. It shouldn't be seen as an act which has new things to say about how to assess capacity, how to access consent. It does have things to say about that, but those aren't the priority. The focus is to help people as far as possible to make their own decisions. And in so doing, they have what is sometimes described as the right to be unwise, or more accurately, what the Act says is that wanting to do something that seems unwise doesn't mean that you lack the capacity to decide to do it. Dignity, bodily integrity, privacy, self-determination and autonomy, those are key themes within the UN Convention, and you will see them at Section 8 of the 2015 Act. Giving effect to past and giving effect to will and preference is something which is seen as very much central to compliance with the UN Convention. There's a duty also to act in good faith and for the benefit of the person, and you will see that there is nowhere in the 2015 Act a reference to best interests, and in that respect this Act contrasts with the current mental health legislation. The Mental Health Act of 2001 has at Section 4 best interests as the principal consideration. I won't go into this slide in detail. What I've set out here are the categories of decision as defined by the Act. They divide up into two broad categories: property and affairs and personal welfare. And all these sort of decisions are decisions which are now capable of being supported within the new structures provided by the 2015 Act. And you will see healthcare there under personal welfare. Of decision supporters, ranging from the decision-making assistant at the lowest and least interventionist tier, co-decision making, which is a process of joint decision-making, and then as a last resort there is still an opportunity to apply to the court, now the circuit court. It's mostly the High Court under wardship, and then a decision-making representative can be appointed by the court, who then takes their authority from the court order and can make decisions on behalf of the relevant person who has been found to have capacity for those purposes. All of these are supervised to varying degrees by the Decision Support Service and are bound by the guiding principles which I've just mentioned. The Act also has things to say about advanced planning, and to that extent it's an Act for all of us, as we could at a future point in our lives lack our decision-making capacity. We already have enduring powers of attorney, but under the 2015 Act, attorneys can be appointed to make healthcare decisions. They'll be under new reporting requirements and supervision by the Decision Support Service. And then advanced healthcare directives, again, are put on a statutory footing by the 2015 Act. And their purpose is to enable persons to be treated according to their will and preference, and importantly, to provide healthcare professionals with information about a person's treatment choices. It's a standard principle and a starting point that treatment is predicated on consent, and that anybody, any adult with capacity, has the entitlement to refuse treatment on whatever grounds. And what the AHD, the Advanced Healthcare Directive, then provides is an opportunity for you to set out that refusal of treatment in advance. And a new creature is created called a designated healthcare representative, essentially a person's agent who will follow through on the Advanced Healthcare Directive. I have a little bit more to say about how these interact then with the Mental Health Act. The Decision Support Service, so that's located in the Mental Health Commission. You'll be familiar with the Commission, and you will know that it already does quite different things to do with the regulation of acute mental health services and the mental health tribunal system. So this takes the Commission in quite a different direction, obviously with a different statutory remit. Just to call out a few then of the functions which are set out in the Act, we will have a duty to promote awareness and confidence, and to support organisational change so that people are supported in the exercise of their capacity. And I will come again to the codes of practice which you can also expect. So just to be clear, we have a regulatory function, but that's in respect of those decision support arrangements. So we don't suddenly have a regulatory duty in respect of healthcare providers. But I suppose these are those which will be important in practice. And looking again at advanced healthcare directives, if a person is being treated under the Mental Health Act, under Part 4, which deals with involuntary detention and the administration of treatment, Then an advanced healthcare directive is not binding if it relates to the refusal of treatment for a mental disorder. So remembering again, an advanced healthcare directive only applies at a future point when you have lost capacity. But if at that point you're a detained patient receiving treatment under Part 4 of the Mental Health Act, then to the extent that your advanced healthcare directive refuses treatment for a mental disorder, it is not binding. However, it is still binding if in your AHD you're refusing treatment of a physical illness. Well, that's been subject to some debate, and indeed an amending bill in 2019 proposed to remove this exception, and that was broadly supported, including by the Department of Health. So we have to see how that progresses and whether that exception will in fact be retained. Another express reference to the Mental Health Act in the Assisted Decision-Making Capacity Act concerns detention provisions, and the Act says this at Part 10, that where during an application to court, which could be the Circuit Court, could be the High Court, as to whether a person who lacks capacity is suffering from a mental disorder within the meaning of the Mental Health Act, then the Mental Health Act procedures will apply in relation to any proposal to detain. And where at the commencement of the Act, the person is already detained in an approved centre under order of the Wardship Court, which can apply in a minority of cases. You may be aware of, if you are working in approved centres, of 1 or 2 people who are there on order of the Wardship Court rather than under the Mental Health Act. Where that arises upon commencement of the Act, the Wardship Court will review, and if the Wardship Court is satisfied that a mental disorder is present, then the court can direct continuing detention for those periods of 3 months, 6 months, subject to ongoing review. And as pertains in mental health tribunals, we'll hear from the responsible consultant psychiatrist and also an independent consultant psychiatrist. And finally then, by way of express reference, the Act does state that nothing in the 2015 Act authorises a person, which could be one of these new decision supporters, to give a patient treatment for a mental disorder or to consent to a patient being given treatment for a mental disorder if at that time treatment is regulated by Part 4. So again, if somebody is involuntarily detained and are being treated under Part 4 of the Mental Health Act, then there's a specific exclusion in relation to the supports or the role of a supporter under the 2015 Act. I hope that's clear. I'll be able to take questions, I think, in relation to that. Now, pardon the double negative here, but at this point in the Act, it doesn't say that the 2015 Act does not otherwise apply. So by calling out this specific exception, I think the 2015 Act is saying that otherwise the 2015 Act is relevant and is to be adopted and to have real meaning within mental health services. So it isn't as if the Mental Health Act relates to mental health services and the Assisted Decision-Making Capacity Act is about all other categories of persons. So what are those broader implications for the mental health services? And here I suppose I'm moving from the specific to the more general, and just by way of suggestion in preparation for commencement, and those of you working in mental health will have your own and perhaps better ideas. You might think of reviewing your standards, policies and processes to ensure compliance with the Assisted Decision-Making Capacity Act, to adapt your existing documentation forms, templates and checklists and so on to ensure that they are compatible with the 15 Act. I presume you have already your own way of documenting how you record consent, for example, under Part 4 of the Act, or capacity to consent. To ensure accessibility of information and appropriate communication tools, remembering again that duty to ensure that people are supported as far as possible to make their own decisions, and that they shouldn't be at risk of being found to lack capacity because their opportunity to communicate is in some way limited. So we would see that access to the Act and to the supports under the Act are very much a new feature of care, and that will include within mental health services. And people working in those services, I guess, will have to become used to interacting with new decision supporters who will have legitimate roles. And to address this idea of the next of kin, this is something which I hope is on the wane, but certainly was very pervasive. The idea that by virtue of a family relationship, somebody describing themselves as next of kin somehow had an automatic decision-making role or an authority to supply consent, which is not now and never has been true. This obviously points to training and professional development requirements, and I'm sure that people in services will have an opportunity to call on their employers and their regulators or the representative bodies to ensure that training, and I know that training has been ongoing including this event, to ensure that training is in place, and as I've mentioned, we in the DSS will be happy to cooperate in that regard. Where are we in the pathway to implementation? The DSS establishment project is well underway. The department was primarily Justice and Equality. We have now moved to the new department, Children, Equality, Disability, Integration and Youth. And they have recently, as recently as yesterday, I think, when speaking to the Oireachtas Committee, have indicated a commencement date of 2022, further off than many of us might like, but that does seem to be on track. Amending legislation and regulation are still being drafted, so the Act itself is to undergo some amendment. There have been various submissions about where it needs to be reconsidered. One of the most substantive amendments, I think, will come with Part 6 and amendments to secure the position of current wards of court. Quite separately, protection of liberty safeguards are being developed by the Department of Health, and they will deal with the circumstances for people who lack capacity to consent or a living situation where they are under continuous supervision and not free to leave, and how to ensure that that is safeguarded by an appropriate legal process, because there really isn't one at the moment. I've mentioned codes of practice already. They are with us already in the DSS in draft form, and those will include codes of practice for health and social care professionals. There will be a code to deal with assessing capacity and supporting decision making, and specific codes in relation to advanced healthcare directives, and all of these will go out for public consultation before they are published by the ministers. Very briefly then, I suppose it's over to one side, but amendments to the Mental Health Act itself are in train. There is a Mental Health Amendment Bill, which is at the heads of bill stage, and that's described as having it as its purpose to amend the Mental Health Act of 2001 to give effect to the recommendations of the expert group review, which I think reported as long ago as 2014, if I'm right. The Mental Health Commission has been providing submissions on draft legislation, and without going into too much detail, a priority for the Commission, my colleagues in the Commission, will be to ensure conformity between the Mental Health Act and the Assisted Decision Making Capacity Act, a consistent approach to those definitions of capacity, consent and voluntariness, compatibility between the guiding principles, and overall a parity between mental and general health, which has always been a key theme for the Commission. So, and I'll finish with this. Much has been made, I think, of the cultural shift that will be involved with commencement of the Assisted Decision Making Capacity Act. And I think whilst there is a lot in it that is new, and I'm sure that there will be some challenges associated with that, I think it's important not to overstate the newness, because person-centred care and participatory decision-making is already the standard, and I've no doubt that people working in mental health services already do that almost without thinking about it. I've set out here what are called the freedom principles, which relate to a human rights-based approach in health and social care, and those ideas of fairness, respect, equality, dignity and autonomy, which are at the heart of the 2015 Act, but I'm sure are very much already at the heart of everything that you do. So I will finish with that. We have launched a website just a couple of months ago. I've set out the web address there. It provides more information and also some detail on where we are as we move towards commencement and the preparations which you might think of undertaking. So thank you very much for listening to me, and I know that I will be available for some questions. Thank you.